Let's talk about the categories of works that are outlined in the Copyright Act. You'll find it under 17 USC 102 little a. Works of authorship include, and they have a list of 8: literary works, musical works, dramatic works, pantomimes, and choreographic works, pictorial, graphic and sculptural works, motion pictures, and other audiovisual works, sound recordings, architectural works. And then I'm going to discuss something called compilations and derivative works as well as part of the categories that are listed. Now, I have a couple points to make regarding the categories before we talk about them specifically. One is they're not mutually exclusive. One work can fall into more than one category. For example, a play. A play might be both a literary work and a dramatic work. My other point, I got a couple points here. My second point is the categories are merely illustrative. It's not an exhaustive list. If a work doesn't fit nicely into a category, it could still qualify if it meets the criteria. For example, like a symphony of odors would not appear to fall into any category, but maybe a symphony full of different smells, it has to obviously fit the other requirements, but nonetheless, we're talking about step 1, works of authorship, and these are the categories. But I think because they are so broad, lots of things fit into them. Something like, for example, a 2 or a 3 dimension object could be a sculpture, could be a graphic, could be pictorial. So it could be a number of different things. We're not setting boundaries here. The reason for these categories of works, though, it's when we talk about statutory rights that individuals have when they have copyright, certain rules are going to apply to only certain categories. So, rights of a copyright holder could vary from category to category. One of the prime examples is sound recordings. They have much more limited rights of reproduction and public performance than any of the other categories. So it's really how they're going to be treated when they have, depending on which category they're in, is what kind of rights they're going to get. And we're not going to be talking about that for a few weeks. All right, so let's dive into our categories. Our first one is the literary works, just kind of straightforward. There's the definitions defined in 17 USC 101, and it's works, and it says not audiovisual works. These are just works that are expressed in words, numbers, or other verbal or numerical symbols, regardless of the nature of the material. Like books. They actually give examples. Books, periodicals, manuscripts, phonorecords, films, tapes, discs, cards, in which they are embodied. So it's broad. So it's bigger than just normal literature. So what are some examples? Plays, short stories, novels, poem, movie scripts, letters, email messages, blogs, computer programs, cooking recipes, a zoning ordinance, maybe. It's got to fit the other requirements, but it's a written in a tangible expression. It's written, it's words. A message on a souvenir t-shirt. Literary work. That would fall under an example of that. But here's a couple other things. What about instructions for assembling a swimming pool? It's words, maybe some numbers, directions telling you how to assemble a swimming pool. It could fall under this category. Remember that just because it falls into the category doesn't make it copyrightable yet. We still have to determine originality and fixation. We're just talking about, does it fit step 1, a work of authorship? Sure does. A warning label on an energy drink. How about a tweet on Twitter? Post a tweet. I don't know how many syllables you get, like 140, something like that. Is that enough, or is that something called a conversation? Could that qualify as a conversation, or is that a literary work? We have poems called haikus, the 5-syllable, 7-syllable, 5-syllable. Is that a literary work? Anyhow, so things to think about. Literary works. We're filling in the blanks on works of art. Musical works. It's actually not defined by the statute, and the term is not limited to any particular type of definition of music. So any work that is musical in character qualifies. Genre doesn't matter, and no particular elements of music, rhythm, melody, or harmony doesn't matter. But this does not include sound recordings. This is any work that is musical in character. So it could be the music and the lyrics. You could have a poem set to music, but a musical work is going to include their music, if there is any, and the lyrics. I mean, an a cappella qualifies as a musical work. So the copyright owners of these have been active in what we're talking about. You're going to see we talk about musical works. There's a whole week for musical works and sound recordings, because their music has kind of shaped a lot of the copyright laws and pursuing litigation, especially with streaming and how easy it is to copy and swap and music and so forth. So when we're talking about a recorded song, we're always going to be talking about a sound recording right and a musical works right. But for purposes of this discussion, musical works has its own category. Dramatic works, with any music that goes along with it. Again, it's not defined by statute like our literary works. Sorry, I got a little sidetracked. I want to kind of step back. See, I can't send my slide back, but I had another thought on the musical works I wanted to share with you. Another example, you don't have to have the words, because you could just have a symphony. You could sing Happy Birthday. An opera will fit into a musical work. Background music of a video game. Okay, there's a recording available on iTunes of Hamlet. Might qualify as a musical work. So think of it broadly. Dramatic works, not defined in the statute, but it's defined in other law books as any work in which performed actions, speech, or incident, or all three convey a theme, thoughts, or character to an audience. Okay, this is our opera too. So here's an example where an opera can fall into a musical recording and into a dramatic work. A play, scripts for cinema or radio or TV, choreographed routine, pantomimes can fall in here. Distinguishing factor is that the actions are intended to be performed rather than just narrated or described. They're intended to be perform the actions. So a song is telling a gripping story about a medieval monarch's life is not going to qualify. Not just the song. It has to have the actions with it. So we already discussed some examples. When we start to move ahead and we talk about rights, there's going to be some restrictions on this as well. We might be able to get some time in to talk about licensing for things and where they fall in. But let's flip to the next one. Pantomimes, choreography. Again, it's not defined in the actual statute, but the Copyright Office regs do have a definition of it. I don't have the number. It's 45003A. If you're into looking that up, I highly recommend you do, so you can see through the rules. Represents a related series of dance moves and patterns organized into a coherent whole. So it's intended to be accompanied by music, and it tells a story. Okay? Doesn't it? But, there's no but. The key here is it has to tell a story. So, what kind of music representation or dance representation might tell a story? Like a ballet, right? A mime, actually a mime. You guys ever see a mime? They got the white gloves and the white painted face, and they just move around. How about gymnastics routine? Professional wrestling matches. I think they're choreographed. A floor exercise routine, maybe? Is this where the playbook of a professional football team, the diagrams, and the roles of the players? Is this where this goes? Possibly. Might also go into literary. Maybe our next topic. Pictorial, graphic, and sculpture works. This is a very broad category, and it is defined by the statute, and it includes 2-dimensional or 3-dimensional works of fine, graphic, and applied art, photographs, prints, and art reproductions, maps, globes, charts, diagrams, models, and technical drawings, which includes any architectural plans as well. So this is, like I said, a broad category. Some examples. I hope they're popping in your head. Sculptures, statues, paintings, a design for a treehouse, a design for a belt buckle, comic strips, advertisements might fall, advertisements that are in magazines or newspapers. Both that might fall under this pictorial, graphic, and sculpture works. What about mannequins? Artificial Christmas tree. What about a lamp? There's going to be some question on those, guys. I'm not going to address them here, but think about them. Keep them at the back of your mind when we switch in about a week or two to the things that are not. We're going to talk about some other things that are not covered in the categories, that are not considered works after we discuss originality and fixation, because you need to actually know those points before we can talk about the others. And just to give you a little sneak peek, something like a lamp, while you might design it, right, it might look like a sculpture, it actually has a useful purpose. You plug it in, you turn it on, it gives you light. That is something that is more protected under patent law. Anything that has a useful purpose, the mannequin has a useful purpose. It's not a statue, it's not a sculpture. We use it to hang clothes and display clothes. Artificial Christmas tree. Maybe a sculptural work, but it's kind of, make the argument it's kind of got a useful purpose. So when we get to those categories, we'll go back to this. So the limitation on this category is that useful articles. I guess I was just going there. The useful articles. So this is only protecting aesthetic features. Now let's go back to the lamp, since I'm here and we're talking about it. Is if the lamp was like a Tiffany lamp, and Tiffany design, it has their own particular design, and you can recognize it as a Tiffany lamp. The base of the lamp might be protected by copyright. Could a work fall into both a literary work and a pictorial and a sculpture? Sure, we just talked about it. Posters, right? You can have literary information on a poster, and it could be a graphic design. Signs, letters or symbols, something like this. You guys have seen this. I think it's called concrete poetry. This could be protected under literary and pictorial and graphic. So another example. All right, the next category, motion pictures and other audiovisual works. These are works that consist of a series of related images which are intrinsically intended to be shown by the use of machines or devices such as projectors, viewers, or electronic equipment, together with any accompanying sound, if any. It's not necessary, regardless of the nature of the material, objects such as films or tapes in which the works are embodied. And this is defined in the statute, the section numbers cited. So what do you need? This is key. You need a machine to show the work. Otherwise you can't see it. Now, obviously, in this, well, even so, you still need a TV or a telephone, or a cell phone or a computer to stream any movie. So you need some sort of machine to see it or to view it. Okay. And you don't necessarily need sound. You can have sound, but you don't need it. So some examples: movies, slideshows, video games, computer programs, my PowerPoints that you guys are listening to, hopefully, fingers crossed. What about a movie soundtrack? I hope you're shaking your head no. That's going to qualify where? I hope you're saying no, we haven't discussed that category yet, because it's going to be under the next one of sound recordings. What's on the movie soundtrack, if there is just different songs, maybe they consist of lyrics and music, those are going to be protected under the musical composition. But the actual recording, the sound recording, is going to be sound recordings, which is also defined as works that result from the fixation of a series of musical, spoken, or other sounds, but not including sounds accompanying in a motion picture or other audiovisual work. What? Wait, but she just said it was going to be in the next one. We'll go back to that. Regardless of the nature of the material, objects such as discs, tapes, or phono records in which they are embodied. To clarify on the sounds in a musical motion picture was different from the example I said. The example I said was movie soundtrack, and when I said it, I guess I should give you a visual. Like, let's say it is on a CD, all right? Or you can go to iTunes and download the entire series of songs. I don't know if they still call it an album, or the soundtrack recordings of the entire movie. And generally, at least the last few that I have seen, you can't just pick the individual songs. Usually they want you to buy the whole recording of the soundtrack. But what the exception is here is what's contained in the movie. The music in the movie itself. Once they take that music and they put it in its own fixed, tangible medium, then it becomes a sound recording. I hope that is clear. But what isn't covered is if they never come out with a movie soundtrack, they just have a movie and it's got music in it, that music goes with the movie for protection purposes. All right, some key points on sound recordings that we got to visit right now, and we are going to hit them again when we talk about the differences between sound recording and music compositions later in the semester. This section was added to the statute in 1972. So pre-1972 song recordings, all that great music from the 60s, and I know there's some students out there who have attempted to use it in their works. I hear those things from the department, thinking they're already in the public domain. What you might be thinking is they don't get federal copyright protection, and that is true. Anything that's pre-recorded 1972 is excluded from federal copyright protection. Ooh, sounds like it goes in the public domain. No, it's not. It's protected by their state law. That's when the state law kicks back in. If they were, when we talked last week and I said the 1976 Copyright Act preempts state law and now copyrights are protected by federal. If it wasn't protected at the time they took the time as designated, or a law comes into effect, then it's not going to be protected. Things like literary works have been protected since the beginning of copyright law, way back the St. Anne Act. Remember, the writings of the authors. So that is very, very old. But the sound recording thing is a fairly new concept. So those 60s, those great 60 songs, still get protection in state courts. So want to make that key exception here. So here we go on some examples of what falls under here. Yes, a recorded song falls on here, but other things like a recording of bird calls, a recording of this lecture. Let's say we're actually in a classroom and I am saying this as I'm in an open classroom, it's not recording unless we hit a record button and then it gets recorded. And then it could be considered a sound recording. It could also be considered the movie slideshow if we put my slides to it. Otherwise, it could just be me being recorded. A recording of a hurricane, if you wanted to be outside and during a storm and record those, and you reduce them to a sound recording. And if you hear my kitty meowing in the background, sorry about that. The point here is the author of a sound recording is the one who makes the creative choices about the content of the recording and who controls the making of the recording. That's what the author gets. And we always have this songwriter versus the producer of the record. I don't want to muddy the waters right here, but that is something that we'll talk about a little later on to distinguish. I want to give you another example. Let's say I go out to the corner of Margaret Street and Broad Street. I think they connect. Tail end of it. I'm out at the street corner at night and I'm recording these sounds of Plattsburgh at night. I got my recorder going on, and maybe there's some sirens, maybe there's some horn honking, maybe there's some yelling, some drunk people walking by, and I record that and I put it down. I own that copyright, and I come and I play it in class for you guys, or I'm like, hey, listen to this great recording, and you listen, and one of you goes, hey, that's cool. And then you go out the next night and stand at the same corner where I was and you record. Did you infringe on my copyright? No, you didn't. It is a literal copying requirement. So you would actually have had to take my recording and then copied my recording exactly for it to be a copy infringement on a sound recording. And we're going to talk more about this right of reproduction when we talk about our specific rights that we have. All right, let's talk about architectural works. This is defined by the statute. It is defined as the design of a building as embodied in any tangible medium of expression, including building, architectural plans, or drawings. The work includes the overall form, as well as the arrangement and composition of spaces and elements in the design, but does not include individual standard features. All right. So the key to this is before the building is built. Even if it's never built, right? This is the design, and the question is what constitutes a building? It's structures that are habitable by humans and intended to be both permanent and stationary, such as houses, office buildings, or other designs that are for human occupancy, like churches, museums, gazebos, the like. You can come up with an example. So the question becomes, if there is a building that was built from a design, and it's standing in a public place. Can I take a picture of it and then sell that picture? Or is it protected by this copyright? Did you guys ever take a picture? Oh, I like that picture. Maybe the Empire State Building. No, there's some limitations that are set on this rule, and you can find it in 17 U.S.C. 120 if you want to take a look. And no, it's just on the actual design itself that is written down and fixed in its tangible meaning. Once it becomes a building and it's in a public place, you can certainly take a picture of it and then sell your picture or have a copyright in the picture. What if I own the building? Can I alter it? Destroy it? Without the owner of the copyright of the design's permission? You design the building, but I own it. I want to knock it down, change it, alter it. No, you can do that too. That limitation is set forth in the statute. So if you own it, you're free to do what you want with it. It's only in the design. Now, if somebody else wanted to buy, like, oh, I love your house, I want to build the same exact house, where do I get the design? Well, the builder, who probably has the copyright to it, unless you designed your own house, they have to get a license to use it. All right, a couple more categories. All right, let's talk about compilations. It's defined in the code, or the Copyright Act, as a work formed by the collection and assembling of pre-existing materials or of data that's selected, coordinated, and arranged in such a way that the resulting work as a whole constitutes an original work of authorship. It's pretty self-explanatory. I mean, that's when you take, maybe a collection of poems and put them into one book, right? Or you put all your photographs onto one CD. The Yellow Pages constitutes a compilation. And these compilations, by the way, can be composed of things that are non-copyrightable elements. We talked about that just a little while ago. What phrases, simple phrases, are not copyrightable, but if you, take a book and put, the book of slang and put a bunch of the slang words in it, those are compilations. Telephone books come with a bunch of facts, and we said that facts are not copyrightable. But if you put them all together in a collection, assembled, it could be something that constitutes a compilation and then is copyrightable. We'll discuss this more under originality. And the last category is derivative works. And these are work based on one or more pre-existing work, such as a translation, a musical arrangement, dramatization, a fictionalization, motion picture, sound recording, art production. Did I work through the whole list already? The big list is up there, and it is defined in the USC Code 17101. A derivative work. Another word or term used you might hear is adaptation. And an example of that is, you take the book Gone with the Wind, or you take the movie Gone with the Wind, and it's based on the novel, right? Harry Potter, that's my favorite example to use with derivative. It's a book, it's a theme park, well, a theme park in Universal, but it's movies, right? And there's characters and dolls, and that is all derivative. Star Wars, right? Star Wars, the movie, and then we have books that I think the books came after the fact, or came just before, on the heels of the movie. But there was books, and there's characters, and there's T-shirts, and anything that stems from a work is a derivative work. And you can actually take something that's in the public domain, like Hamlet. It's in the public domain, and you can create your own interpretation or derivative of that Hamlet, and then your work becomes copyrightable. Whatever you do with it depends on what form or category it goes in. So these are the categories. We're also going to talk about derivative works as a right that a copyright holder has. That's going to come up when we talk about those statutory rights a little later this semester. So we just finished up works of authorship. The next topic we're going to cover is element number 3. So if you got your work and it falls into one of these categories, or it's determined to be a work of authorship, then the next question is it original?